If you have been following the news about immigration in America, you already know that things have been changing rapidly over the past year. But what is coming in February of 2026 could reshape the entire landscape of immigration policy in ways that will affect millions of people across the country. Whether you are an immigrant yourself, have family members going through the immigration process, or simply want to understand how these changes might impact your community, you need to pay close attention to what I am about to share with you today. The United States government has been working behind the scenes on a massive overhaul of immigration procedures, and many of these changes are set to take effect next month. Some of these updates will make the process easier for certain groups of people, while others will create significant new challenges that could catch many applicants off guard if they are not prepared. Let me start by talking about what is happening with visa processing times, because this is something that has frustrated millions of people for years. The backlogs at United States Citizenship and Immigration Services have been a major problem, with some applicants waiting years just to get a decision on their cases. In February of 2026, a new processing framework is being implemented that will fundamentally change how applications are handled. Under this new system, cases will be prioritized based on a combination of factors including how long an applicant has been waiting, the type of visa being requested, and whether the applicant has any special circumstances that warrant expedited review. This might sound like good news, and for some people it will be. However, the flip side of this new prioritization system is that certain categories of applications may actually see their wait times increase as resources are shifted to other areas. Employment-based visa applicants in particular need to understand these changes. The government is introducing new requirements for employer sponsorship that will take effect at the beginning of February. Companies that want to bring foreign workers to the United States will now need to demonstrate more clearly that they have made genuine efforts to hire American workers first. This is not entirely new, but the documentation requirements are becoming much more stringent. What this means practically is that if you are currently in the middle of an employment-based immigration case, you should contact your employer and your immigration attorney as soon as possible to make sure that all the necessary paperwork is in order. Cases that were filed under the old requirements may need to be supplemented with additional evidence, and there are strict deadlines for submitting this information. Family-based immigration is also seeing significant changes. The government has announced new rules regarding the Affidavit of Support, which is the document that sponsors sign promising to financially support their immigrant relatives. Starting in February, sponsors will need to demonstrate a higher level of income or assets than was previously required. The specific thresholds vary depending on family size and location, but in general, sponsors will need to show income at 150% of the federal poverty guidelines, up from the previous 125% requirement. This change alone could affect hundreds of thousands of pending family immigration cases. If you are sponsoring a family member and your income is close to the current threshold, you may need to find a joint sponsor or provide additional evidence of assets to meet the new requirements. Do not wait until the last minute to address this, because finding a qualified joint sponsor can take time. Now let me talk about something that has been getting a lot of attention in the news, and that is the changes coming to asylum and refugee processing. The administration has been working on a complete redesign of how asylum cases are handled, and the new procedures rolling out in February represent the most significant changes to the asylum system in decades. Under the new rules, asylum seekers will be required to undergo an initial screening interview within a much shorter time frame than before. The goal is to quickly identify claims that have merit and separate them from claims that do not meet the legal requirements for asylum. While supporters of these changes say they will help genuine refugees get protection faster, critics argue that the compressed timelines do not give asylum seekers enough time to find legal representation or gather evidence to support their claims. If you or someone you know is currently in the asylum process, it is absolutely critical to understand how these new timelines work. Missing a deadline under the new system could result in a case being denied, and the opportunities to appeal or reopen a case are becoming more limited. The changes are not just affecting people who are trying to come to the United States. There are also significant updates coming for people who already have green cards and are thinking about applying for citizenship. The naturalization process is being modified in several important ways. First, the civics test is being updated with new questions that reflect more recent American history and government. If you have been studying the old list of 100 questions, you will need to make sure you are also familiar with the new material that is being added. The good news is that the passing score is remaining the same, so you still only need to answer 6 out of 10 questions correctly. but the questions themselves may be different from what you have been practicing. Second, the English language requirements are being more strictly enforced. There have always been exemptions for older applicants who have been in the United States for many years, and those exemptions are not going away. However, for applicants who do not qualify for an exemption, the standards for demonstrating English proficiency are being raised. Immigration officers will be paying closer attention to whether applicants can truly read, write, and speak English at the required level. Third, and this is important, the continuous residence and physical presence requirements are being more carefully scrutinized. If you have taken any trips outside the United States during your time as a green card holder, you need to make sure you have documentation of those trips and can explain any extended absences. The government is implementing new systems to track travel more accurately, which means that discrepancies between what applicants report and what the records show will be easier to detect. Let me also address what is happening with enforcement priorities, because this affects not just undocumented immigrants, but also people with legal status who may have had run-ins with the law. The new enforcement guidelines taking effect in February place a stronger emphasis on removing individuals who have been convicted of certain crimes, even if those crimes were committed many years ago. This is particularly concerning for green card holders who may have old convictions on their records. Under immigration law, certain crimes can make a person deportable even if they have lived in the United States legally for decades. The new guidelines direct enforcement officers to prioritize these cases, which means that people who may have thought their old legal problems were behind them could suddenly find themselves facing removal proceedings. If you are a green card holder with any criminal history, no matter how old or how minor you think it might be, I strongly encourage you to consult with an immigration attorney before the new guidelines take effect. There may be options available to you, such as applying for a waiver or seeking post-conviction relief, but these processes take time and you do not want to wait until you are already in removal proceedings to explore your options. Now, I want to talk about something that does not get as much attention but is incredibly important for many families, and that is the changes coming to public benefits and how they interact with immigration status. The government has been revising its policies on what is known as the public charge rule, which determines whether using certain government benefits can affect your immigration case. Starting in February, immigration officers will be looking more closely at whether applicants for green cards or visa extensions have used public benefits in the past or are likely to use them in the future. This does not mean that using any public benefit will automatically disqualify you, but it does mean that benefit usage will be weighed as part of the overall evaluation of your case. This is particularly relevant for seniors and people with disabilities who may be receiving benefits like supplemental security income or Medicaid. If you are in this situation and you have an immigration case pending, you need to understand how the new public charge guidelines might affect your case. In some situations, it may be possible to overcome a public charge finding by demonstrating other positive factors like employment history, education, or family support. There are also changes coming that will affect students and people on temporary work visas. The optional practical training program, which allows international students to work in the United States after graduation, is being modified. The eligibility requirements are becoming stricter, and the application process is changing in ways that will require more advanced planning. If you are a student on an F1 visa who is hoping to use OPT after graduation, you should talk to your school's International Student Office as soon as possible to understand the new requirements. The changes take effect in February, which means that students who are graduating in the spring semester will be among the first to navigate the new system. Similarly, people on H-1B visas and other temporary work visas need to be aware of changes to the extension and transfer processes. The government is implementing new verification procedures that will require employers to provide more documentation when filing for visa extensions or when an employee transfers to a new company. These additional requirements are likely to increase processing times, at least initially, so planning ahead is more important than ever. I also want to mention the changes affecting people who entered the United States under humanitarian parole programs. Over the past few years, the government has allowed hundreds of thousands of people from countries like Ukraine, Venezuela, Cuba, and Haiti to enter under parole. Many of these individuals have been living and working in the United States legally, but their parole status is temporary. In February, new guidelines will clarify the options available to parolees as their initial authorization periods begin to expire. For some people, there may be pathways to extend their parole or transition to another immigration status. For others, the options may be more limited. If you entered the United States under a parole program, you need to understand what your specific situation is and what steps you may need to take in the coming months. The changes I have been describing are complex, and I know it can be overwhelming to try to understand how they all fit together. But here is the key message I want you to take away from this video. February of 2026 is going to be a significant month for immigration in America, and the people who prepare now will be in a much better position than those who wait until the last minute. Whether you are applying for a visa, sponsoring a family member, pursuing citizenship, or just trying to maintain your current status, now is the time to review your case, gather your documents, and make sure you understand what changes might affect you. I also want to emphasize the importance of getting reliable information. There is a lot of misinformation out there about immigration, especially on social media. Some people will try to scare you with exaggerated claims, while others will tell you not to worry about changes that could actually have a real impact on your case. The best thing you can do is get information directly from official government sources and from qualified immigration attorneys. If you cannot afford an attorney, there are nonprofit organizations in most communities that provide free or low-cost immigration legal services. The government also maintains a list of accredited representatives who can help with immigration cases. Taking advantage of these resources is much better than relying on rumors or advice from people who may not fully understand the law. As we wrap up, I want to remind you that while the changes coming in February are significant, they are not the end of the story. Immigration policy in America continues to evolve, and what takes effect next month may be modified further in the months and years to come. The most important thing is to stay informed and to take action on your individual case based on the most current information available. If you found this video helpful, I encourage you to share it with friends and family members who might be affected by these changes. The more people understand what is happening, the better prepared our communities will be. I will continue to bring you updates as new information becomes available, so make sure you are subscribed to this channel and have notifications turned on. Thank you for watching, and I wish you the best of luck as you navigate the immigration system in the months ahead. Stay informed, stay prepared, and remember that you are not alone in this process.